SJC-12014, Michael Parr v. Daniel Rosenthal.
Mr. McDonough, good morning still.
Thank you. Good morning, Mr. Chief Justice, and may it please the Court. My name is Miles McDonough. With me is James Hamrock. Your Honors, we represent Dr. Rosenthal. We seek reversal of the Appeals Court decision and reinstatement of the judgment in favor of Dr. Rosenthal that had been entered in the Superior Court. What I would like to do, Your Honors, this morning is point out and underscore 4 legislative developments, 3 of them enactments over the last 40 years, and the other an acknowledgement by the legislature as to certain public policy concerns in the world of medical malpractice that I would submit to the Court clearly evince the legislature's intent that this Court's rule first arrived at in Hendrickson versus Sears, the discovery rule, and also arrived at in the medical malpractice context in the Franklin case, is, according to the legislature's intent as well, what is to be used by the trial courts in determining statute of limitations issues. That's the trigger. To the exclusion of what the appeals court adopted as the so-called continuing treatment tolling method.
You don't disagree that when Alberts versus Devine was enacted, was written by Justice Hennessy, or Chief Justice Hennessy, I can't remember now, it was interpreting the same, that wasn't the legislature saying, yeah, it's fine to put a discovery rule in here. That was court imposed.
Your Honor, if I could just start with this history, I think we have to go back to 1974, which is when Hendrickson comes in. The court decides Hendrickson, and it's on the heels of Hendrickson, which is a classic discovery rule.
Which is legal malpractice.
Yes, Your Honor, but nonetheless, the term accrue is construed by this court, and the court comes up with the discovery rule where what you need is it's disjunctive, either constructive or actual notice of harm and relation to the defendant's conduct. Simple, workable rule.
Help me to understand what that means in the context of a surgeon. Language is know or reasonably should have known that the plaintiff's been harmed as a result of a defendant's conduct, correct? That's the standard?
Yes, Your Honor.
The doctor does a surgery. There's a known risk of complications arising from that surgery. Patient suffers complications from the surgery, may or may not have resulted from anything that the doctor did wrong. Are you saying that mere knowledge of complications from a surgery is that the clock starts once you are aware that there were complications coming from a surgery?
No, I think the clock starts precisely under I think the articulation is notice of harm, actual or constructive, and causal relationship, complication or not, it's relationship to conduct, Your Honor.
Well, I know, but clearly the surgery was the conduct. When you have a surgery, you say, listen, I'm going to be going into your body and doing this, and when this happens, there's a 15 or 20% chance that there'll be this complication. It wouldn't have happened but for the surgery. But I guess there's a difference between knowing I had a known complication arising from a risk of surgery, which may or may not relate to anything the doctor did wrong, versus I had some knowledge that this complication arises from an error by the doctor.
I don't think that I'll call it the informed consent component changes the analysis, Your Honor. I think the legislature intends, and following up on Hendrickson, and I think Franklin is consistent with this, I think the intent of the legislature is that discovery, as the court has articulated it, plus 3 years is adequate, fair
You haven't
time.
answered my question. The question really is, I'll make it as blunt as I can. Does the clock start once I know there is a complication arising from the surgery, or does the clock start when I know that there is a complication from the surgery which may have resulted from an error by the doctor, as opposed to the fact that sometimes not everything works out?
Your Honor, the fact of a complication can further inform, but the clock starts at the moment of harm, with knowledge of harm, when knowledge of harm and knowledge of conduct related to the harm.
So is it that I need to know that the complication arose from some error by the doctor? Is that when the
No,
clock
no, you have
starts?
3 years in order to discern that, Your Honor.
Okay, but that's what I'm trying to figure out. When does the clock start? Does the clock start upon knowledge of a complication, or does the clock start upon knowledge of a complication which I have reason to believe was because the doctor made a mistake?
It is not the latter. It is if you are informed of a complication and you have harm, injury, Your Honor, that's the key. It's injury, notice of injury, and notice of relation to conduct. The cases are clear
So
in
you
using
would
the
say
word
in this
conduct.
case, the clock started right after the operation when the Dr. Ebb or whoever it was came out and said, there's been a complication, there's a burn. It started right then. Is that
Precisely,
right?
Your Honor. In a context where, and that's only one marker, but in a context where the plaintiffs were aware that the procedure was going to entail the use of an instrument to burn tissue, and in a context where they knew it was Dr. Rosenthal, and the plaintiffs, within 1 week, it was conceded on the record, it was conceded in the trial counsel's
So what
closing
should they have
that
done?
were
They
aware
should
of-
have said,
I'm sorry?
he's at fault, let's take him out of Mass General, let's go to Lowell General Hospital. I mean, it just seems crazy to me.
You mean to take him out immediately, Your Honor? Is
Yeah.
that what you're?
Well, you're
that
saying, oh,
didn't-
well, you've got 3 years, but I thought.
There has to be a balance, Your Honor, and the legislature has struck that balance.
Well, Mr.
And-
McDonough, complication doesn't necessarily mean injury.
Correct.
Because,
Yes, Your Honor.
I mean, I'm helping you out here. Because complication is something that could naturally occur because of the
Certainly.
nature of the procedure. The patient is informed that this could possibly happen. A complication occurring is very different from knowing that you've been injured, because you would have to know not only that the complication happened, but that it happened not as a natural course, but because the physician did something wrong,
No.
right?
No.
I believe
I'm
that,
asking, is
Your Honor,
that your idea?
right, I want to be very clear that knowledge of a physician or anybody doing anything wrong is not an element to get the clock ticking. That's not it. That's why that's where the 3 years comes in from the legislature. Actually, and the standard is knowledge of harm, actual or constructive, the fact that you have been harmed, there's some sort of harm going on, and that there is a relation to conduct.
So what
Whether
is the
negligent or
harm?
not
Is the harm the complication then, or is the harm what the doctor did wrong?
It depends on what you mean by complication. If it's a complication that doesn't involve any substantial harm, it's a complication. But harm is the key.
Does it make any
Appreciation of
difference?
harm- I'm sorry, Your Honor.
I'm sorry, go ahead,
I
finish
was
your.
saying it's appreciation of harm coalescing with appreciation of actual or constructive causal relationship,
What
actual or
was the
constructive.
jury instructed here?
They were
They had
instructed-
to consider and conclude on this point.
They were given a discovery rule instruction, Your Honor.
Right, which was in essence,
Was
no
it
reasonably
within
should have
what-
known that he's been harmed as a result of the defendant's conduct, right? Or something
No,
to
I
that
believe it was whether or not the plaintiffs had filed pursuant to, and then there was substantive instruction regarding the statute of limitations by, I think it was March 6, 2009. So it's a specific date with the jury having been instructed, and
But what was the jury instructed as to this the discovery rule as to what they must know, as to when the clock starts.
What knew or reasonably should have known type standard,
known
Your
what?
Honor.
They had been harmed by the conduct of the defendant.
But the conduct of the defendant was the operation, not necessarily that he had been negligent, correct?
Correct.
Is there any legal significance to a complication for which there had been informed consent and a complication for which there had been no informed consent?
I think
For
the
purposes of the
significance in
discovery rule.
Well, in a this is not an informed consent case, Your Honor, it's a negligence case, but in the discussion of a complication from a doctor, such as Dr. Rosenthal here and Drs. Raskin and Ebb, all of that is further information. The legal significance is that that is something that could be considered by the jury and perhaps was, in order to inform on the question of whether the plaintiff knew or should have known and satisfied the requirements under the discovery rule. If I may, I do want to...
So you're saying that the clock started when the parents knew that the burn was caused by the ablation? That basically there's a burn that wasn't there before, and they knew that they were going to be using this burn method.
Where they knew Dr. Rosenthal had administered the procedure, they knew the procedure entailed the administration of heat to the leg, and they knew that the burn location was 13 centimeters remote from where the RFA was being done on William's calf.
And how were they supposed to know that there was negligence on the part of the doctor if the doctor continues, put aside the group theory for a moment, if that same doctor continues to be treating the patient?
They have 3 years to consult either with counsel or with an expert or a combination of both.
The statute of limitations period, the language is exactly the same for legal malpractice and medical malpractice, right?
Yes, Your Honor. Accrue. It's an accrue.
Accrual. But this court has interpreted in Smith versus Murphy that the continuing treatment or continuing representation in the legal...
And we're getting back to where I wanted to start.
Okay.
I'm going to have to go through this a little bit more quickly than I would have liked. Chapter 60D, Section 60D of Chapter 231 is enacted in 1975 on the heels of this court's pronunciation of the discovery rule in 1974. At that time, the discovery rule is established and it's adopted by the legislature, and that's significant to differentiate from the medical malpractice, a legal malpractice, context. You don't have that analog over in the legal malpractice
What do you mean
side.
it's adopted by them?
When under the Condon versus Heitzma case, Your Honor, when the legislature takes a term like accrue and a definition like the discovery rule that's imputed into the word accrue by this court and puts it in a statute, that's legislative intent. The legislature is deemed to be aware of what this court has done, and that is reflective of the legislature's intent.
Okay.
At that time, Your Honor, also the legislature knocks out 18 years of potential tolling by simultaneously taking out the minor claims tolling statutory provision. Section 60D's language, adopted on the heels of Hendrickson, has never changed to this day. In the interim, the legislature recognizes the medical malpractice crisis and the medical, that's discussed in the brief, so I'll leave it at that, but there's a lot of development in the 80s on that. As a result of that, in 1980, this is the 86 legislation, where the legislature keeps the discovery rule. They do not adopt a continuing tolling rule, and they eliminate more tolling, the 3-year tolling associated with the administrator or appointment of representative provision. So again, the legislature is consistently knocking down exposure, not increasing it on the part of doctors. The Davros case of this court regarding the 86 legislation states, expanding the scope of damages available to plaintiffs who are the victims of medical malpractice and the period within which to make such claims is contrary to the express intent of the legislature in enacting Statute 1986, Chapter 351. They didn't just put in the statute of repose there, they kept the statute of limitations as it was. Clear evidence in the 2012 legislation of the legislature's intent vis-a-vis rejection of continuing treatment tolling is there, and the preservation of the discovery rule, because in 2012, in enacting Section 60L of Chapter 231, the legislature actually uses a discovery concept to excuse plaintiffs from complying with the new presentment provision that gives plaintiffs have to present a claim within 182 days. The defense gets to look at it. The goal is hopefully there'll be discussion. Some claims can be resolved that way. It's built right into the statute, the discovery concept, that if the claimant can't identify, can't discover the healthcare provider in question, they're excused. By that time, the legislature was fully aware of Rudenauer, but the decision by this court, fully aware of Harlfinger. This court had discussed time and time again the notion of continuing treatment tolling, and the legislature rejected it in 2012. It could have said, we're going to excuse claimants who don't comply with the notice provisions because their doctor is treating them or while their doctor is treating them. They didn't do that. They went instead with the same workable, common sense, fairest, most generous rule in the country, by the way. Massachusetts statute of limitations, discovery plus 3 years, is the most generous rule in the country for plaintiffs. So this is a situation where the appeals court stepped in and made a public policy call that was not within its appropriate role. There's an awful lot of complicated stuff that the legislature is still wrestling with here. They've required the Attorney General and the Department of Public Health to report back to them on this. The work, the appeals court decision in Malpanis from the 80s actually disagrees with what this panel did. Malpanis said, discovery rule works fine. 3 years is plenty of time to sort out whatever needs to be sorted out before filing suit. So, Your Honors, I see my time is running. If I may just quickly wrap up.
Your time is up, but you
thank
can
you, Your
get
Honor.
a sentence or two if you want to close.
Oh, thank you.
If you want a sentence or two, but that's all you
Okay.
get.
The legislative intent has been clear since 1975. The statute of the discovery rule works very well. The appeals court did not factor in the entirety of the medical malpractice problem and all of the subsidiary problems in there. If there is a change, Your Honors, it is only for the legislature. This court's rule works well, so we seek reversal of the appeals court decision. Thank you very much.
But can I ask you a question?
Certainly.
You mentioned something I missed, I couldn't, the Davers case?
Oh, Davers. I think it's the Davers.
Davors.
Your Honor, the PLF amicus brief has a discussion on this. It's Darviris.
Okay, because I didn't see it in your brief, and I just...
Yeah, yes, Your Honor.
Okay,
Davers. I
All
think it's
right.
2008, as I recall.
Thank you. A
Thank
very
you, Your Honors.
compound sentence, Mr. McDonough, but still a
I
sentence.
asked a question,
No, I
Chief.
understand. No, I'm referring to before the question. There's no question. The question is appropriate.
May it please the court, David Gallagher for the plaintiffs, William, Michael, and Michelle Parr. If I can, obviously, we're here to ask the court to uphold the appeals court decision in regards to the continuing treatment doctrine, which tolls, according to the appeals court, medical malpractice claims, so long as the plaintiff receives continuing treatment for the same injury or illness caused by the alleged negligent or original physician, even if the plaintiff knew or should have known of the injury, subject obviously to the 7 years.
But why? Knew or should have known of the injury and who committed it? Why doesn't that end? 3 years, bingo. You got 3 years from that point.
Well, I think this goes to the two general purposes of the continuing treatment doctrine. One of which is essentially the same finding that was in the Murphy case, which is that the party receiving the continuing treatment, or in the Murphy case, the continuing representation, is not in a good position to determine the cause and what happened. That's kind of one of the major reasons that one of the things the continuing treatment doctrine is intended to protect the patient from potential concealment by the physician.
Well, that's a whole, concealment's a whole nother
Right,
ground.
understood.
That's not what we're talking about here,
Right.
concealment.
So the one argument is the same one in the Murphy case, is we're not in a position to judge the cause, what happened here.
We know we've been harmed, for sure.
We know we've been harmed.
And we know it was a result of the operation that went bad.
Well, we know we've been harmed. We know we've been burned.
Right.
During that procedure. The evidence before the court was, we don't know the cause. In fact, the evidence before the court was that the doctors, all 3 doctors of part of this sarcoma group, none of them know the cause. It's a remote burn. There's 13 some odd centimeters between the zones of ablation, the intended burn zone, and where this burn occurred. Nobody knows why it happened. Indeed, their own expert witness testified during the trial that it was very difficult to relate the zones of ablation to the burn that occurred in Will's leg.
So when do you say the clock starts? Does it start upon knowledge of the complication, or does it start upon know or should have known that it was the doctor's error which caused it?
I think it's the latter, and the cases talk about the fact you need to know or have knowledge or sufficient notice of harm, knowledge or sufficient notice of the cause of the harm, and I think most recently, knowledge and sufficient notice.
Under Cantu, I mean, isn't it really that, isn't Mr. McDonough right, without a continuing treatment, that traditional discovery rule would say knowledge of harm and knowledge that the harm was caused by the defendant, but not necessarily that it was the result of negligence, right?
I think that's right. And the problem here is that for the purposes of the Parrs, they never learned the cause. They asked about the cause.
Well, they knew that the cause was from the operation.
Well,
right?
they knew that he was burned during the operation.
So why did they ask about the harm?
Because they wanted to know what happened. They wanted to know.
They wanted to know what happened because it appeared as though something had gone awry.
Yeah, but they don't know whether this is an expected potential result. All they're told is it's a complications, it's a superficial burn, he should be fine. That's what's in the record. So they continue to ask, and again, this goes back to one of the purposes of the continuing treatment doctrine is, defendant makes much in the brief about the fact that after a short period of time, they stopped asking. And they stop asking because they're in that peculiar, difficult position where Will is continuing to be treated by this specialized group, and it's a difficult situation for them to continue to ask questions about how did this happen when they're being treated.
What did the surgical site look like post-surgery? I mean, was there a bandage over it? Were there stitches?
Well,
Not the burn, but the surgical site.
There were bandages.
Okay.
On the surgical side.
And the burn was 13 centimeters away.
Right in the back of the knee, in essence.
And the whole procedure involved essentially burning.
No question. No
Was
question.
what it was the procedure that was
Right.
being used.
And
No
when was the first amputation, the below-the-knee
March
amputation?
20th of 19...
And I mean, but in relation to the actual ablation procedure?
Well, it would have been, it eliminated most of...
No, but I'm just, in terms of time, was it the same month? Yeah.
No, the first amputation was in March of 1986.
2006.
The operation was in November of 2005.
Okay, so it's about 4 months, 4 months later.
Right.
Okay.
The other purpose of the continuing treatment doctrine, which the court talked about as being the compelling basis here, is to prevent the interference with the physician-patient relationship as long as it exists. And that is the purpose there, is to allow the doctor who has the best knowledge about what happened.
Does that come from some sort of legislative background or history?
No, that really comes from
Make that
other
up.
cases that have talked about the jurisdictions that have adopted the continuing treatment form in one.
It's not a legislative judgment, and so we shouldn't assume that the legislature, if it was considering this, would consider that to be more important than some of the other interests in here.
Well,
that inhere in statute of limitations.
right. If I understand the question is that a legislative function that balancing?
This balance.
Well, I don't think so, and I think that the problem with the argument that has been made on the legislative history is I think that argument can easily be flipped, because this court has made it clear, certainly since Franklin, that it is up to the court to determine what the factors that lead to the accrual of a cause of action. The Franklin case talked specifically about that. And so certainly, and that was in 1980, so certainly in 1986 when the statutes were revised to add the 7-year statute of repose, it can be argued that the legislature was certainly aware at that point in time that the judiciary kept control of defining when a cause of action accrues, unless, and the case says, unless there is specific legislative direction.
So why didn't this cause of action accrue when the first amputation occurred?
I think that that's a good argument that that possibly did, because at that point in time,
If that's the case, then it was timely filed.
Correct.
Because, and we wouldn't even be talking about this because the 3-year statute of limitations would have been March of '09, late March of '09, and here your suit was filed March 6th of '09. So what happened with that fact in your case?
well, I think the court made the or I should strike that, the jury made the determination that
That wasn't the date that they
apparently
actually
not,
knew
because,
when
correct,
the
because
burn
they made the
happened.
decision that the Parrs knew or reasonably should have known prior to March 6th of 2006.
So what date were you saying when you argued the case to the jury? What date were you saying was the date of the harm?
Well, I was not trial counsel, so
But do you know?
My recollection of the record is that the argument was made that it was at least the first amputation, the below-the-knee amputation, the March 20th, 2006. So that would have made the action timely.
Because as of them, they would have known that the conduct was caused by Dr. Rosenthal?
Well, certainly at that point in time, they certainly would have known that the continuing efforts to try and treat the burn were unsuccessful. They weren't able to save the leg. So therefore, certainly by that point in time, I think an argument could be made, subsequent to that point, but I think you can certainly make, I think, a reasonable argument that as of that first amputation in March of 2006, that they were aware that they were harmed, and that the continuing treatment was not going to be able to save the leg. So I think that's arguably a potential date to start the statute of limitations to run.
Why should actual knowledge not end, even if you're correct about continuing treatment? Why should actual knowledge not be sufficient?
Well, again, I mean, if the sole controlling reason for the continuing treatment doctrine is to protect the patient during that period of time because they're not in a position to obtain that knowledge, then you could certainly argue that actual knowledge should, end the case. But the compelling reason, as found by the appeals court, and as we would argue, is that the compelling reason is to continue to preserve that physician-patient relationship. So whether you have actual knowledge or not shouldn't matter. And there are, I believe there's 8 separate jurisdictions we would disagree with defendants' interpretation of some of the cases, but there's two federal districts and at least 8 other state districts that have reached that conclusion that that's the compelling reason, to preserve that physician-patient relationship. And so actual knowledge, even though you may know that the doctor committed negligence and caused your harm, you may believe that that doctor, because of that knowledge, is in the best position to try and correct the harm. And he's also obviously has the most incentive to correct the harm, both to protect the patient that he's harmed, he or she is harmed, and secondly, to avoid the litigation.
So under this view, medical malpractice, or the rule of continuing treatment, differs or separates from the rule as it applies to legal malpractice, because
Correct.
actual knowledge does toll the statute.
Right.
I mean,
That's
or,
right.
or get the statute running,
Right.
Right?
That's right. I mean, the Murphy case made that clear, that actual knowledge will end the tolling provision of continuing representation. And this...
So why shouldn't the patient be responsible for the time that he or she continues with the physician after they know that they've been harmed? I don't understand how continuing treatment doctrine prevents the patient from doing that, at least initially. I mean, you still have the 3 years to try to work it out, and if you know, why should the patient have the benefit of that? They can just sit on that if they know it.
Well, I suppose theoretically that's true. I think the theory behind it, Your Honor, is that during that period of time that the patient is being treated by the same physician and/or group that caused the harm.
I get that. I'm saying there's nothing wrong with that, but there's no reason why the statute should be told while the patient is desiring to seek continuing care, but at the same time knows that this person has caused me harm.
Well, I think the problem, as the other jurisdictions that have adopted continuing treatment despite actual knowledge, the problem that those cases discuss is that even in that circumstance, in essence, you're interfering with the physician-patient relationship. Because if I know that this physician caused me harm, and this physician is providing me continued treatment, then theoretically, if that treatment lasts for close to 3 years, for instance, then I'm forced at that point in time to file suit while I'm still receiving continuing treatment from that physician. And I think that's the problem. That's interfering with the physician-patient relationship.
I'm sorry, finish.
And so it's putting the patient in the difficult position of deciding, what do I do? The doctor, I think in good faith, is continuing to treat me, and it seems to be helping, but now the statute of limitations is about to run. Now I have to make the choice of either foregoing the action and losing my legal rights to bring a claim, or bringing that action, stopping that treatment most likely, and then having to try and reinstate or start that treatment with another physician.
So I was a little confused by the back and forth on what jurisdiction does what, but how many jurisdictions in the United States say, in the medical malpractice context, that actual knowledge doesn't make a difference?
By my count, by my research, 8 states
Say that actual knowledge
does not make a difference.
doesn't start the clock running. 8 jurisdictions say actual knowledge,
Right.
have the continuing treatment doctrine, and say actual knowledge does not
Correct.
make a difference.
And 2 federal, the Second and the Fourth Circuit as well.
All right, we'll check on that.
But I mean, in the legal malpractice area, we characterize what you must know as that the attorney misrepresented something, that we basically expect you know that your attorney screwed up, and once you know that your attorney screwed up, then we say it's over. But in what you describe with the medical area, you may not know that the doctor has screwed up. You just know that he burned your leg, and that as a result of that burning the leg, that's why it's sort of this idea of what you actually know depends upon when we say the clock starts.
Right.
Go
And
ahead.
and I think that's right. And I think my understanding of the case law on that is, again, you have to have knowledge or sufficient notice that you were harmed, the cause of the harm, and that the defendant caused the harm. And the defendants, the medical providers, under the continuing treatment doctrine as adopted by the appeals court, continue to have the protection of the 7-year statute of repose. So they don't have the ultimate problem that they have asserted that somehow that this is going to result in a plethora of stale claims.
But that's where you confuse me, because isn't it plain that the doctor, isn't it plain upon the finding a burn that this doctor caused that burn? I mean, he didn't have a burn before he goes into surgery. He gets the ablation, and now he has a burn. Is there any doubt that the doctor caused the burn?
Well, I mean, we don't know what caused the burn. We know that he went in without that burn and he came out with a burn. I mean, we certainly know that. And the testimony that was at trial was they continued to ask what happened, why is this burn, and they were told it was a superficial burn, and he was.
But was there
gonna be
any
fine.
doubt that it was the surgery which caused the burn?
There's no, I don't think there's any doubt that something happened during the treatment to cause the burn. And the problem is that there is nobody, including the doctor, the defendant in this case, the other doctors of the group, all the other doctors at Mass General, nobody has been able to determine the cause of that burn.
Well, specifically what went wrong.
What
but
happened?
Certainly the cause was the operation with this tool, which caused the burn. We don't have enough time to explore this other question. It's sort of, when is a group a group? But let me ask one question. In this case, is the defendant doctor here, does that doctor share profits with the other people that were giving the continuing care?
There's nothing in the record that specifically addresses that. As I understand the record, there is some evidence that the billing was done by the same billing entity.
Well, that's a different story.
Right, and
Everybody
so-
at Mass General bills through Mass General. That doesn't mean they're all in a group practice.
Correct. There is no, my recollection is there's nothing in the
Trying to
record.
figure out
about
when a group is a group for these
Right,
purposes, and
right.
profit sharing might be one of those. Okay,
that. Okay, thank you, Your Honor.
Thank you.